This is a bit like giving a maths lecture Friday afternoon after lunch. There are no slides. I've got two visual aids. That's a pamphlet on the Red Book. And that's Hammond's collection of transcripts and other notes and publishes the Bathurst ritual case. That's in the library. So they are my two visual aids. Let me start. Archbishop Mowll and the Red Book case. This topic I've been given today is that, Archbishop Mowll and the Red Book case. This sounds like a title to an Agatha Christie mystery or another Enid Blyton adventure for the famous five to solve. Now, there is a mystery about Archbishop Mowll's direct connection and involvement with this case. The Marcus Loan biography of Mowll has no mention of the Red Book case. The Centenary History of Mowll College, by the same author, omits any mention of the case in the chapter dealing with the principalship of T.C. Hammond. The Sydney Dyson magazine, published monthly during Mowll's time, makes no mention of the case, either by way of news or in the Archbishop's monthly letter. Mowll's presidential addresses to the annual sessions of Sydney Synod from 1943 to his death in 1958 make no mention of the case. In the April 1947 number of the Sydney Dyson magazine, Mowll refers to a meeting of the Provincial Synod as, quote, a very happy and useful gathering. Surely not an apt description if there is a court case about to erupt between, quote, Sydney, unquote, and Bathurst, quote, unquote. Before I explore the connection between Mowll and the Red Book case, let me briefly outline the chronology of the case in the courts. The plaintiff was the Attorney-General for the State of New South Wales, and the defendant was Arnold Lomas Wild, Bishop of Bathurst, and the Church of England Property Trust, Bathurst. The information concerning the case was filed in the Supreme Court 19 April 1944. The case was heard by Mr Justice Roper, the Chief Judge in Equity, who has a plaque in St Mark's, Darling Point, and it occupied 7 hearing days in September and October 1947. Judgment was reserved and then delivered in the next February in favour of the plaintiffs. Bishop Wild appealed to the Court of Appeal, or the full court in those days, and by a majority, 2 judges to 1, they dismissed his appeal. Wild then appealed to the High Court of Australia, and that took 5 more hearing days. That's with witnesses in the box and barristers arguing. That took place in August 1948, and judgment was delivered in December of that year, 1948. Now, for some unstated reason, only 4 High Court judges sat on the case, and they were evenly divided, 2-2. Now, there's an Act of Parliament called the Judiciary Act, which comes into play, and the effect of that was that Roper's judgment in the Supreme Court of New South Wales was affirmed. Would Wild then appeal to the Privy Council in England? There was a lot of toing and froing. In the end, Wild agreed to abandon the appeal to the Privy Council, and in return, the informants, that's the plaintiffs, agreed to accept a payment of £100 as a nominal figure for costs. They had been awarded, obviously, because Wild had lost in the Supreme Court and the High Court. Costs were awarded against Wild, and they were fairly substantial. If you have a solicitor and a barrister and a senior barrister, you pay their costs and you pay the costs of the other side. So, it was a fairly large sum. However, the deal that was done was the plaintiffs would not press for costs. They would accept £100 and Wild would not go to the Privy Council. So that meant that there was really a victory for the plaintiffs in the court system. But what was the case about? Why was the Attorney-General for the state involved? In short, when you read the case reports, they show that some 23 parishioners in the Diocese of Bathurst, they represented some 8 parishes, objected to the use of a service book, which is called the Holy Eucharist. It carried the endorsement of the diocesan bishop. The book reprinted the 1662 Book of Common Prayer Service for the administration of the Holy Communion with additions. The book had a red cover. The parishioners contended that the additions were not lawful. They were not lawfully authorised and therefore a breach of the charitable trusts for the use of the land on which the parish church was erected. The main instigator was a Canowindra solicitor, one Ernest Athol Sharp. The enforcement of charitable trusts requires the Attorney General to give his approval to any case, and proceedings are mounted in the name of the Attorney General. Hence, when you read the case headnotes, it's got Attorney General New South Wales v. Wild. Who were the lawyers? The plaintiffs or / informants instructed a man called Minton Taylor, who was a senior partner at Allen and Hemsley. Now, for the lawyers amongst us, they'll know that that's the senior firm in Australia. And Minton Taylor, his name appears in just about every constitutional paper dealing with the Anglican Constitution debates between 1920 and 1961. He's a major player in those debates. So he was a partner at Allen's. He briefed a junior called Henry and a senior called Clive Teese, King's Counsel. Teese was a well-regarded barrister. He'd won 3 university medals going through university and was very well regarded. The defendants instructed a firm called Roxburgh & Co. They briefed a man called A.B. Kerrigan, who I'm told was the second boy enrolled in Trinity Grammar School and later on became the Chancellor of Newcastle, and a man called F.C. Kiddo, Queen's Counsel, who ended up as a High Court judge. So I can say more about the lawyers if there's question time. It's only fascinating to lawyers, this sort of stuff. Now, what do we know about the proceedings, the events before the court hearing? What brought it to this stage? Ruth Teal says that the Red Book was distributed for use in the Bathurst Diocese in Advent 1942, so a couple of weeks before Christmas 1942. Opposition to its use arose in a number of parishes. The parishioners took their complaint to Archbishop Mowll as Metropolitan of New South Wales because they could get no satisfaction from their own bishop, so they went the next step up. And because the Bathurst laymen were seeking advice on their ecclesiastical and legal rights, Mowll referred them to T.C. Hammond of Moore College. That's according to Teal. At a parish meeting in July of 1943 in Canowindra, a letter from T.C. Hammond was read out at the parish meeting, and that critiqued in great detail the Red Book. And Bishop Wild was not able to answer questions about that correspondence. There was further correspondence, and just before Christmas 1943, Allen and Hemsley, the solicitors for the informants, wrote to Wild's solicitors. And I've got a long quote which will appear in the printed version, but I'll just pick out some bits. So they write to Wild's solicitors and say, may we be permitted for our own part to say how much we regret the position which has arisen and how reluctant we are to carry out our instructions, but we feel the position is not of our clients' making and that they have every justification for taking such action as they deem necessary to protect their rights and the rights of other members of the Church of England in the diocese. So they're apologetic. Then they go on to say, it's a real pity or a tremendous pity that in a time of war, a controversy such as this, having such far-reaching effects, should be allowed to continue or to have even been initiated. And they then remind the bishop that after some 30 years of patient effort, we are very close to securing a constitution which will then make adequate provision for pre-book revision. And they go on a bit about that, and they then ask the bishop to withdraw the manual throughout the diocese, and if this is immediately done, of course, we will not file the information and statement of claim which is in the course of being filed. So that's the lawyer's note. That Mowll was already aware of the Red Book is evident from a letter he wrote to Wilde in 1944, which says, "My dear Bishop, I now have had time to read the Red Book and the other papers you sent me in connection with it. If I may say so, I think you would be well advised to withdraw it from use in your diocese. Believe me, yours sincerely, Howard Sidney." Now, I assume that at some stage Wilde would have sworn an oath of canonical obedience to his metropolitan. But was that of any effect? We know from subsequent events in New South Wales these sort of canonical obedience promises have no effect at all, but nevertheless people still make them. Bishop Wilde did not withdraw. At this point, Mowll is no longer part of the printed narrative, and I can find no printed sources to connect him. Teal says that Mowll referred the aggrieved layman to the principal of Moore College, the redoubtable T.C. Hammond. Now, if one is to enter the jousting lists, then it's imperative to engage the best champion. And in a biography of Hammond, there is this instructive passage. Such litigation had frequently taken place in England in the second half of the 19th century, as churchmen tried to resist the intrusions of ritualists and Anglo-Catholics. The shelves of Hammond's study in Dublin had contained bound volumes of the Transactions of the Church Association, which Bishop Ryle had described as being necessary to the defence of England, as were the Army and Navy. Areas of contention were well known: crucifixes and roods, the confessional, altars, the mixed cup, wafer bread, prayers for the dead, etc., etc. Bewildering to even sympathetic non-Anglicans as these things may be, for embattled Anglicans they were the flags and battle markers of a huge attempt to turn back the Reformation. Hammond himself, as we've seen, had been embroiled in a similar case in Ireland. Now, the Red Book, as I said, was literally a book with a red cover. It had the Book of Common Prayer, service for the Holy Communion, and some additions. The additions were actions and ceremonies. The book had a commendation over the name of the bishop. There was a similar book in use in Riverina, but that had a blue cover. But it didn't have the bishop's commendation in Riverina. Now, what were these additional ceremonies? There was a ringing of a Sanctus bell at particular points during the service, making the sign of the cross at various other points, and other bits and pieces. The Supreme Court, as I've mentioned, held that the additional ceremonies were illegal as they are contrary to the trusts on which the property was held. It's clear that Hammond's involvement was the driving force in the litigation. After the case concluded, he published the Bathurst ritual case, some 260 pages of documents and transcripts of evidence. And if you get the book out of the library, you can read Broughton's evidence. He was asked, was he an expert? He said, well, people say so. And you can read, that was typical Broughton. There's no suggestion in the preface written by Hammond that he was doing this exercise on behalf of Mowll. In Mackintosh's chapter on Hammond, Mackintosh credits Hammond, quote, for his prosecuting for Mowll of the long court case against the Bishop of Bathurst. In the time available to me, I've not been able to locate any documentary evidence that Hammond was directed by Mowll. So the Diocesan Archives, I've not yet been able to turn up anything. There's a lot of correspondence when Mowll was away in England, which I'll mention in a minute, between the registrar, that's Don Robinson's father, and Mowll, letters backwards and forwards, cables backwards and forwards about appointments parish appointments going on in the diocese, all sorts of things going on, but no one mention of this case. It's curious. The most comprehensive study of the Red Book case is Galbraith's PhD thesis, followed by Teal's journal article referred to earlier. Both are sound starting points for further examination of the case. However, both are written from a firmly held Anglo-Catholic perspective, and subsequent authors tend to draw on the Teal account. It would be remiss of me not to set this 5-year episode of the Red Book case in its wider context. The Allens letter of 1943 places this controversy in a time of war. So by December 1943 in Europe, all sorts of things had happened, but I'll pick out a couple. The dam busters have conducted their raid, the Allies had retaken North Africa, and the famous Australian 9th Division was on its way home to defend us from the enemy. Closer to home, Pearl Harbor had fallen, Hong Kong had fallen, the sinking of the Royal Naval ships Repulse and Prince of Wales had occurred, Singapore had fallen, and the cruiser HMAS Perth was lost in the Battle of the Sunda Strait, where the casualties included the ship's chaplain, the Reverend Ronald Bevington, an Englishman who was a licensed clergyman in the Diocese of Sydney. In January 1943, Army Intelligence Officer Donald Robinson was able to attend a church service with Padre Marcus Lone in Port Moresby. That's January 43. By May, Lone's unit was assigned to Mowll to join with the Americans in repelling the Japanese. Lone administered to the wounded and buried the dead as he trudged over the Bulldog track on a dozen times or more. So much for 1943. But you'll recall that Roper heard the case in September and October 47, but before judgment was delivered in December of 47, the Archbishop had left for the 5-week Lambeth Conference to be held the next year in London. Archbishop Mowll and Mrs Mowll left Sydney, went to Perth, then caught a boat to East Africa, where he visited and preached visited for CMS missionaries and preached. Then he went to the Congo, West Africa, and then on to England. The 5-week Lambeth was followed by the First Assembly of the World Council of Churches, as we've heard earlier, and then the Moulls returned by flying boat to Rose Bay in October. So they were away for almost a year. So why would a court skirmish on churchmanship occupy front of mind for the Archbishop of Sydney? So I think he was quite content to allow Hammond to do it. I'm trying to find documentary evidence. There's none to date. I understand that whenever Archbishop Mowll was able, he would have Friday lunch at the college, would spend the afternoon with Hammond. So you would think, filling in the gaps, that they would have had conversation. A postscript. Let me conclude quickly with a postscript. Teal suggests 2 reasons for antagonism between Sydney and the country dioceses of the province of New South Wales. First, when the original Diocese of Australia was divided, and I quote now from Teal, country dioceses justly felt that they had been inadequately endowed in buildings and clergy at the time of their separation from Sydney. They bemoaned the way in which the Sydney Diocese had appropriated the Moore estate, left originally to the Diocese of Australia, but used as the foundation endowment for the college that bears its name. Booing and hissing, stamping of feet. Secondly, differences in churchmanship became embedded in the various dioceses in the first half of the 20th century. Relationships varied between strained to animosity. However, when Sir Marcus Lone became Archbishop of Sydney and later Primate, relationships throughout Australia, and particularly with the other New South Wales bishops, was worked on and improved. As part of this, he initiated grants of $25,000 to Riverina and Bathurst. And I'll quote now from Blanche's biography. The money would be a gift from the funds of the Endowment of the Sea to the endowment funds of those 2 dioceses. When the endowment was established in 1855, the Diocese of Sydney had within its boundaries the areas that became the Diocese of Riverina and Bathurst. Lone saw it as a matter of principle that they are a portion of the Sydney funds and will be shared in the way he proposed. He saw it as right and fair. So did the Synod. Not only did it pass the proposed ordinance, but amended it to provide gifts of $25,000 each to the endowment funds of two additional dioceses, Armidale and Grafton. Lone initiated two further gifts of the same amount to the four dioceses in 1980 and 1981. In 1990, Archbishop Robinson initiated grants of $100,000 to the four dioceses. So that deals with the gripe. In February 2018, the dire financial position of the Diocese of Bathurst led the godly, gospel-minded Bishop Palmer to meet with Archbishop Davies to talk frankly about the situation, knowing that the Diocese of Bathurst would be unable to fund his successor. A plan was developed. The overriding concern was not to see the demise of Anglican ministry in Western New South Wales. Bishop Barker's vision was to see the gospel expand and grow with churches committed to Christ throughout the whole of New South Wales. So when Bathurst and Goulburn were created, there were evangelical bishops put in place. So the conversation between Archbishop Davies and Bishop Palmer came up with a plan, and it was suggested that if the Diocese of Bathurst were willing to elect a new bishop with the approval of the Metropolitan, then this would be a tangible expression of partnership between the two dioceses, and both diocesan synods endorsed a plan where the Diocese of Sydney would provide $250,000 per annum to fund the episcopal and registry functions of Bathurst for a period of some 6 years. So I've mentioned that when Bathurst was originally separated in 1870, Barker was able to secure the nomination of Samuel Edward Marsden, the grandson of the great Samuel Marsden. And Marsden, the new bishop, was described as resolutely evangelical. With the election of Mark Calder as Bishop of Bathurst in 2019, resolutely evangelical episcopal leadership has now come full circle.
The question is, does a copy of the Red Book actually exist, perhaps in the Mowll College Library or somewhere?
I've not seen one. I can't answer for the library. I'm sure there were quite a lot published, printed and distributed. I'm sure they're in existence.
The question is, has anyone done an analysis of the Red Book innovations compared to the 1928 English innovations? Yeah, 7, 8, yeah.
I'm not aware, but most of these innovations, the 1928 book that was knocked off in England, gathered together a whole lot of these innovations that came out of the Anglo-Catholic movement and then found its way into things like this manual.
The question is, how did Bathurst go from an evangelical beginning to the Red Book in a limited amount of time as an answer?
Short answer, I don't know, but when you read other books on that sort of general topic, like the one that's written about Melbourne, it's to do with, I think, the bishop of the diocese and the bishops, I think, in selecting training clergy, and the whole thing can slip away. I think that seemed to be the secret.
Mark, the principal of Mowll College has just checked the library catalogue and has informed us that we have 3 copies of the Red Book available to borrow. Thank you very much. For research purposes. The question is about the relationship between the Red Book case and the dynamics around discussion of that and the development of the Constitution, the links therein.
I think this is a book crying out to be written from an evangelical point of view. The book that's out at the moment is by Davis, is a very readable book. He does a lot of work. I've found at least one mistake. he makes an assertion that someone moved something. When you actually read the General Synod minutes of that session, the person that was supposed to move something was defeated, and so I don't know quite what he's talking about. So someone needs to do a lot of careful work and set it in its wider context from an evangelical point of view. And from the Sydney evangelicals, there was some division. There was a small group consisting of Broughton Knox, Donald Robinson, Marcus Lone, I think Roderick Johnson, a couple of others, who still said, no, we don't want it. In the end, when Marcus Lone became Archbishop, he said, well, that's the one we've got to do, we've got to make it work. But there was a small group who went to the upper house in New South Wales when they were putting the bill through and objected to it. They wanted the upper house guys not to pass the Act of Parliament. Gough got them in the office like a headmaster and told them all off. And there's all sorts to do about it. So someone needs to write that up in their retirement or some other time.
The other thing, I'm taking the opportunity to make a comment, related to this, what's seemed, from my research, seemed to be spooking some of these conversations is the South African question. This is what I'm writing about, but I thought I'd spare you too much energy today by giving you a paper on it as well. But I'm researching the South African question with the Church of the Province's construction of their own constitution and discussions between Mowll and the Archbishop of Canterbury and the Church of the Province and the Church of England and South Africa, bringing them back together. The worry about Anglo-Catholicism and a constitutional form of that. It's interesting to me that Minton Taylor is the one who supplies the Church of England and South Africa with a draft constitution. So I'm just agreeing, I suppose, and just saying the South African question is in the discussions of, in the mind of Mowll and others at the time, looming large.
I'll be very quick. And this is the lawyer's comment. If Wilde had gone to the Privy Council in London, and a lot of people in England didn't want that to happen because it would have opened up all sorts of questions, and who knows whether Wilde would have won or not won, but the Privy Council was the court of appeal for the dominions and the colonies of the empire, and any decision they made was not binding on the English courts. The top court in the English system was the Judicial Commission of the House of Lords. They were the same judges. The Judicial Committee sat in Downing Street, just a couple of doors down from number 10. The Judicial Commission of the House of Lords sat in the House of Lords in the committee room. But they were the same judges. But two different systems. One was persuasive, but the Privy Council would have been binding here. South Africa, when the South Africans had their constitution put in place in the 1870s, they precisely put a clause in, I can't remember the clause number now, which cut out any binding effect of Privy Council decisions on the new South African Church, because there was a series of Privy Council decisions about ritual and ceremonial, and they wanted to cut those out. We've retained those.
Which is why the Church of England and South Africa has always claimed that the Privy Council ruled that the Church of the Province...
ones.
Church of England, South Africa, the Franklin Test and so forth, they've always claimed that the Privy Council ruling on this question, which said that the Church of the Province cut itself off root and branch from the Church of England.
From a lawyer's point of view, that's right.
Yeah, therefore the Church of England and South Africa has the claim that it never left.
We've still got a claim on Bishop's Court there, Eddie, yeah.
The question is about the Charities Act in the rural dioceses, and has that any relevance for today's discussions and debates?
Short answer, no. It's not so much the Charities Act, it's to do with the general law of charities, which goes back to 1600 something or other in England. It's a long act that's very interesting to lawyers. All Anglican property in New South Wales is held on what's called a purpose trust. So it's got to be used for the purposes of the Anglican Church in the diocese of wherever, or the parish of Broken Hill or whatever. And it's enforcing that purpose that brings you into the equity court. That's a general view. So
the Mathis case was able to be brought because they had departed from their purposes?
Yes, that's right. It couldn't happen today because we've changed the internal rules to allow variations in services.
Okay. Can we thank Robert for his answer to those questions?